They had better produce the child to Mr. Hill. They had better produce the child to Mr. Hill. Stop talking. Stop talking. Whoever has care, custody, and control of the minor witness.
This case is already heating up before we even dive in. We've got the people versus Christopher Tripp, a man facing child abuse charges in the 4th degree. That's serious, and the courtroom knows it. What makes this case even more dramatic is the tangled web of family involvement. We've got a child witness who may not even be cooperating, a mother who might be interfering, and a judge who is clearly ready to drop the hammer if people start playing games. This isn't just about one defendant, it's about the system making sure a vulnerable child is protected and that justice isn't derailed. Stick with me, because as you're about to see, the judge in this case does not hold back. He's fiery, blunt, and willing to make threats of arrest right in the middle of the hearing. Trust me, you're going to want to see how this unfolds.
All right, I'm ready on Shabazz. No, I'm sorry, Tripp. I'll do Tripp first, because did you tell me Tripp was ready earlier?
Yes, Your Honor.
I'm ready on Tripp. And what are we doing on Watson Wilson? Am I coming down for a trial?
We have a resolution, Your Honor, PTR. We're in receipt of what we want.
Okay, this is case number 244438701. The people versus Christopher. Might be Lorenzo is cut off on the docket. Tripp, defendant is charged with child abuse 4th degree. Today is the date set for final pretrial conference appearances, please.
Morning, Your Honor. Alex Hill on behalf of the people.
Here, Mr. Tripp will continue. Dennis Stevenson on behalf of Christopher Tripp. Mr. Tripp, please say your first, middle, and last names.
Christopher Lorenzo Tripp.
All right, Ms. Stevenson, how are you proceeding? Because you was getting ready to tell us.
Right. Mr. Tripp is going to continue his plea of not guilty, but I would ask for sidebar with the court and the people.
Right now?
If I'm
This might help.
So that means you all want me to come downstairs because Mr. Hill is not on this thing?
But he and Miss Coleman did come in here or something.
Okay.
Okay, thank you, Your Honor. We're gonna go into the room right now.
All right, come into the room.
Thank you, guys. Thank you for your patience.
Then I guess we need to go to breakout. Wouldn't it be funny if we just started talking right here? Join me in breakout room number 1. All right, back on the record with the people versus Christopher Tripp. Man, I'm only gonna let you talk to him for about another minute.
Okay, Your Honor, we were having, thank you very much for that, Grace. Trying to just figure out how Mr. Tripp can help the people to have a conversation with the complaining witness's mother.
Wow, did you catch that? The judge isn't mincing words. He's saying, in no uncertain terms, if the child's mother doesn't respond, he'll send the police straight to the school, take custody of the child, and even issue arrest warrants. That's not just courtroom drama, that's the raw legal reality of witness interference. Think about the stakes here. This isn't just about showing up to court. It's about the credibility of the justice system. Without that child's testimony, the case falls apart. Question for you, do you think the judge is being too harsh here, or is he right to push this hard to make sure the witness is produced?
Oh, well, I'm gonna tell you how we're gonna have a conversation with him. If she don't answer the phone the next time, if she doesn't respond to that text the next time, I'm gonna send the police out there. I'm gonna send the police to the child's school. And then we're going to take care, custody, and control over the child. And then they'll have to get the child from protective services. So let me be clear. Let me be clear out of my mouth. Let me be clear. If Mr. Tripp resides with the mother, then he better go home and tell her that she better answer Mr. Hill's phone call. She better respond to his text. and she better produce my witness, because failure to do so is going to cause me to show cause her, and I'm going to have her arrested. Listen to me clearly and carefully. I'm going to have her arrested, and I'm talking about the mother of the child. Whoever has care, custody, and control over the child, they had better produce the child to Mr. Hill. They had better produce the child to Mr. Hill. Stop talking. Stop talking. Whoever has care, custody, and control of the minor witness.
Here's where the judge draws the line in the sand. Witness tampering. That's not some minor threat, it's a felony. If the mother or anyone else tries to hide the child or prevent testimony, they're looking at brand new criminal charges on top of this case. The judge is laying down the law because without the witness, justice is impossible. This moment really shows the tension in family-based abuse cases, protecting the child while also forcing cooperation from caregivers who may have divided loyalties. If you were the judge, would you take this same hard stance or try to handle it differently?
Had better produce the witness to Mr. Hill. Failure to do so is going to result in me contacting protective services, in me issuing an arrest warrant for interference with this criminal prosecution. It is going to result in charges for witness tampering. Listen to me carefully and clear. I'm not playing. Now, the case can be resolved, and I will entertain pretrial resolutions, which will include in-person classes. But what I will not do is allow some person to bully this court system. It's never going to happen. The bullying of this court system, it's never going to happen. So whoever has the child, I know the baby got a cell phone. It's 2025. But what I also know is that she's in school. She's in school. Either she being homeschooled, and that address has to be registered with the state, or she's in a physical school. And she's going to talk to Mr. Hill. The witness is going to talk to Mr. Hill. And if the mother has custody, they're going to produce the child. If Mr. Tripp has custody, he's going to produce the child. Whoever fails or refuses to produce the child, I'm going to have those charges issued against them. And we're going to have a warrant for their arrest. All right. Now, any further facilitation, that's y'all business. If Mr. Hill comes back here and tell me that they still not answering his calls, he can't find his witness, this minor witness, it's going to be somebody is going to have to deal with that, and they're going to have to deal with me.
That was a striking comment. The whole family needs some classes. You can almost hear the frustration in the judge's voice. Family conflict cases like this often expose deeper issues than just the criminal charge itself. Parenting classes, therapy, counseling, they're not just punishments, they're tools to prevent future harm. What's interesting here is that the judge can mandate classes for the defendant, but not for the others involved. That gap shows how limited the court's authority can be when dealing with family dynamics outside the defendant's control.
Anything else before I get a date?
Thank you, Your Honor. Nothing by the people further.
So for the date, Your Honor, in that, we would have to be able to arrange the in-person classes.
Sound like the whole family needs some classes, but I can't make the other people go to class. Does Mr. Tripp work?
Not at this time, Your Honor.
Oh, well, then he could go to the classes. But I don't know where the in-person classes are. You know, I'd be thinking Mr. Rice can do anything. I feel like he has all the classes, but those may not be free, so I do understand that. I'm not opposed to it. Maybe you need to get a referral from probation.
This is where the human side of the case hits. Tripp suddenly claims he's suffering a seizure or panic attack right in the middle of court. Whether it's genuine or a tactic, the courtroom pauses. And that's a reminder, these aren't robots in court. Defendants feel fear, pressure, and stress. Judges have to balance compassion with skepticism. Is this a real medical emergency or an attempt to delay proceedings? You can see how quickly the energy in the room shifts here. How would you react if you were the judge? Press forward or pause to get medical proof?
Okay.
But, yeah. And I am live streaming right now. So if you want to go back and play this for her, you can go back and play this for her. If you don't have if somebody don't have they don't want to say it with as much fervor as I'm saying it, the video is going to be there. You just show her this is what the judge said. And I mean it from the complete bottom of my heart. I mean it. I mean it. I mean it because I feel like she's trying to bully the system and trying to whatever. And I'm not going to have it. I'm not going to have it. Okay. So let's do this. And I want at least 6 classes in order for me to accept the pretrial resolution. What I'm saying is, Trip, you can't listen to her, talk to her, and listen to me at the same time.
I just explained to her, I have seizures and right now I feel like I'm having a panic right now. I have medical issues for it.
Now, you're not gonna make me put you in the Wayne County Jail and mark your file medical.
No,
Okay, well, take a deep breath. We're gonna take a deep breath. If you need some water, they can give you some water. But let me say this to you. You can take a deep breath. And if you need some water, they can give you some water. Because court is stressful. And if the stress is going to trigger whatever you're having, then we're going to need to get you some medical attention.
So now the judge is giving Tripp a path forward. 6 mandatory classes before the court will even consider a resolution. That's significant because it shows the judge isn't just punishing, he's trying to rehabilitate. But he also sets firm trial dates, showing this case is moving forward whether Tripp cooperates or not. That's the balance courts often strike, accountability paired with opportunities for reform. Do you think requiring classes is fair here, or is it just another hurdle for the defendant?
All right. I'm going to set it for at least 6 weeks, 8 weeks out, because I want 6 classes in order for me to entertain the pretrial resolution. So I could put it October 29th, but I won't. I will put it. Oh, I can't put it. Oh, I could put it November I could put it November the 3rd. Yeah, I'll put it November the 3rd for final pretrial conference. And then I'm going to go ahead and put it on my trial docket as well, November 3rd. And so then I'm going to put it on the trial docket for December 2nd. So let's put November 3rd at 9:10. And then I'm going to put it for a jury trial. December 2nd. And know that it is first in priority. That's why I put it on the 2nd to make sure. And that's at 9:30. So if the matter doesn't resolve, and then, all right. And then I want to have to lock nobody up while they wait in order to get the witness for the trial. Anything further on behalf of the people?
No, Your Honor, thank you.
On behalf of the defense?
No, thank you, Your Honor.
All right, we're all set then. Everyone have a great day. Stay safe.
Thank you very much, Your Honor.
And that wraps up the People versus Christopher Tripp for now. What we saw today was a judge refusing to let this case get derailed. From threats of police action to warnings about witness tampering, the court made one thing crystal clear. The system won't tolerate interference, especially when it comes to protecting a child witness. Tripp now has a chance to complete classes and possibly resolve the case. But if he doesn't, trial is locked in. This case highlights the tension between protecting victims, holding defendants accountable, and managing complicated family dynamics. What do you think? Was the judge too aggressive? Or was he just doing what it takes to uphold justice? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Trust me, you don't want to miss what's coming next.